So hi, everyone. Thank you so much for joining us for the ACLU of Rhode Island's 2023 Supreme Court of the United States wrap-up event. We're really happy to be with you here today. We're happy to be able to talk about this term with you. Just a few very brief housekeeping items before we start. This event is being recorded. We can't see any participants, so don't worry about that. But if there's anything during the event where you're really excited to return to it or hear what one of our amazing panelists had said previously, we will be posting this event at some point, so definitely be on the lookout for that. But again, just to reiterate, no participants will be filmed, even though the event is being recorded. The second thing I want to just bring up is that we do have a Q&A box. You should be able to see it at the very bottom of your screen. It just says Q&A and it has 2 speech bubbles in it. If you click that at any point, you can submit a question to our panelists. We're not going to really be answering questions while our panelists are talking. We're going to kind of try to keep that towards the end of the event, just to make sure that we can get through, again, everything that our amazing panelists have to say tonight. But please, please, please feel free, if you have any questions during the event, to submit them to that Q&A box, and we will try to get to as many as we can at the end of the event. Finally, we will be concluding this event at around 7:15. I know it can be agonizing waiting for the Supreme Court to even release decisions, but it will not be so with the timing of this event tonight. So really quickly, we're going to begin. I do just want to very briefly introduce our staff members who are on this call. We have Zoe Chakoyan, who is our comms associate. And we also have Monica Smith, who is our new development associate. So I'm really excited to introduce them tonight. And then we also have Megan Kachadorian, who is the assistant to the director and who is a very important person in this office. So without further ado, I also just want to introduce our panelists. First, we have Stephen Brown, who is the executive director of the ACLU of Rhode Island. We have Sonia Dio, who is a solo practitioner in Providence. She focuses on employment discrimination and civil rights types cases. We have Jared Goldstein, who has been a professor of law at Roger Williams University since 2005, where he teaches constitutional law and civil rights. His book, Real Americans, National Identity, Violence, and the Constitution, was released last year. Starting in fall 2024, he will be directing a new prisoners' rights law clinic at Roger Williams University School of Law. We also have Diana Hassel, who has been a member of the faculty at Roger Williams University School of Law since 1995. She teaches in the areas of constitutional law, civil rights litigation, and race and the law. Professor Hassel received her JD from Rutgers Newark Law School and a BA from Mount Holyoke College. We also have Lynette Labinger, who is a longtime ACLU of Rhode Island cooperating attorney and a very well-known civil rights lawyer who, over the course of a few decades, has successfully litigated numerous challenges to state anti-abortion laws. And finally, we have Camille McKenna, who is an assistant public defender at the Rhode Island Public Defender's Office. She has nearly 20 years of experience representing clients in criminal appeals and post-conviction matters, both in state and federal court. Attorney McKenna received her JD from Roger Williams University School of Law and has a BA from Hartwick College. So as you can tell, we have an amazing panel tonight, a lot of brilliant, brilliant people. So we are going to get right into the decisions. What you'll see tonight is that this Supreme Court term really did have some very important victories for civil liberties, but unfortunately it also had some very profound and significant losses. So I'm going to turn it over first to Diana Hassel to talk about the first case of the night, which addressed affirmative action.
Hi, everybody. Thank you for the opportunity to talk to you all. So as I'm sure you've heard, the Students for Fair Admissions case against Harvard University and the University of North Carolina essentially overruled Grutter and removed the possibility of the use of race in admissions in higher education. So as you know, with any race-based classification, the court has historically determined that it must pass strict scrutiny, which means there must be a compelling state interest and it must be narrowly tailored. And the Students for Fair Admission Court, Justice Roberts, determined that diversity, educational benefits from diversity in higher education was not an appropriate compelling state interest because it was too vague, it was not concrete, it was unmeasurable, it was not time limited. For all of those reasons, considered not a compelling state interest. And then secondly, the way that Harvard and UNC went about their admissions, which is using race as a factor among many other factors in creating a diverse class along many different parameters, was not narrowly tailored. They described it as a stereotype, lumping different people together just based on their race, portrayed a stereotype, that it was a kind of a quota, a kind of racial balancing. So neither a compelling state interest nor narrowly tailored. While Grutter and Bakke and Fisher were not explicitly overruled, they were in effect. So what this means is that race cannot be used, race cannot be used as a factor in admission. So the fact that a person is of a certain race cannot be considered while in making the decisions about admission. Some interesting sort of cracks and possibilities in this decision, however, is that Justice Roberts said that, of course, while you can't use race as a factor, the race of an applicant might be relevant to admission if it is part of their story of how their race impacted some other part of their identity, impacted their role as a leader, impacted their resilience, impacted their story of why they were committed to this or that school. So it seemed like it opened the possibility, which was picked up on, of course, in the dissents, that in the personal essays that students write for college admissions, if they talk about how they had to overcome various challenges and this led them to be, stronger, smarter, tougher, more of a leader because of their race, that is relevant. So that opens up a kind of a difficult scenario for admissions professionals. How can they, when are they using race not in and of itself, but race as sort of a part of someone's identity in other aspects of their character, and so figuring out when they could do that and when they can't, I think, will be a project going forward. Roberts also cautioned that, oh, don't think you can do this in some backdoor way, and we won't understand what you're doing. So if what admissions offices do is in essence go back to using race, that will be prohibited. What this court really hammered heavily on is its belief in the very strict colorblind intention of the 14th Amendment. And they used various historical evidence, and of course picked out language from Brown and other cases to argue that the purpose of the Equal Protection Clause was not to undo the disadvantages of the freedmen or to undo the history and the impact of racial hierarchy, but to remove race ever from being used by the government. Of course, the dissents have a very vigorous and persuasive argument about how that was never the case. And in fact, right after the adoption of the 14th Amendment, there were race-based benefit programs for the formerly enslaved, so that it was not understood to be colorblind. But clearly the agenda of this court is to argue emphatically that any use of race, whether to disadvantage a minoritized group or to help undo systemic racism, will not be allowed and is not consistent with the spirit and the meaning of the 14th Amendment. Another interesting wrinkle in this case is that the Justice Roberts, again, who wrote the opinion of the court, says in a footnote that the military academies are not parties to this case, and therefore this ruling may not apply to them. The military academies may have a compelling state interest to create a racially diverse officer class in a way that general colleges and universities don't, which raises a whole host of interesting questions, like why does the military need racial diversity, but the medical profession doesn't need racial diversity, the teachers don't need racial diversity, but if the military academies can claim some sort of national security requirement for a racially diverse officer class, maybe they will get a waiver of this approach. So that's another kind of tantalizing issue left to be explored.
Amazing. Thank you so much for that summary. That was really wonderful, and I think gave a very well-rounded description of that decision. So thank you so much. Really quickly, I just want to remind everyone, you can ask questions in the Q&A box. And then one thing that I forgot to mention at the very beginning for housekeeping is we are happy to have closed captioning available for this event. That should also be available. It should be right next to the Q&A box at the bottom of the screen. So please feel free to enable that at any time. And I apologize for neglecting to bring that up when I first started this webinar. But now I would like to turn to, unfortunately, another civil liberties loss that we saw at this time for LGBTQ rights and non-discrimination. And so I'd like to go to Attorney Dio, please.
Thanks, Hannah. I'm here to talk to you about the 303 Creative case again. And I have a really hard time today, as I did when I initially spoke on this before the term went forward, balancing out which way this was going to go and which way it should have gone and all of these other things. But essentially what the Supreme Court did is they find that Ms. Smith, who is a web designer or going to be a web designer, can't be compelled to create websites for same-sex couples because that was her firmly held religious belief. And somewhere in there, Ms. Smith says, you know, it's got nothing to do with serving gays and lesbians, but it's got to do with my firmly held religious beliefs. In essence, this really puts a lot of things in question. This is what Colorado had done is set up a statutory scheme, much like we have here, that protects individuals from discrimination based on their membership in particular classes, sex, age, orientation, religion, disability, et cetera, et cetera. And what this does, what this decision does is sort of say, but you can discriminate if it's going to force you to make public speech that you don't think you should have to make. And it's really problematic because this creates a situation where a lot of discriminatory actions are going to be able to be covered by the excuse that, well, you know, it's my religious belief that says I can't do that. You know, I find that offensive. I don't want to make this speech. I don't want to create this book. I don't want to create this website, this cake, whatever it happens to be, because it's against my religious beliefs. So as I look at this, this is sort of a decision that it's very scary. At the same time, when you're looking at First Amendment protection, the First Amendment itself provides us as citizens of this country with a lot of different protections to say what it is we want to say, things like coming and petitioning the court and doing all things like that. So yes, we really do want to do things to try to protect the First Amendment. But what this did here in a lot of ways is create a very patent way for individuals to, in small companies actually, to discriminate against individuals because of their orientation. I would say that I didn't find this decision to be terribly surprising after the decision came down against Mr. DeJoy, which was, I think, a few days later. And in that matter, the court essentially said that for an employer to deny someone the ability to take time off for a religious reason, that they had to show an actual hardship, not just sort of de minimis interference with them. And in some ways, you know, that creates a lot of protection. Again, on this First Amendment, which isn't just speech, it's also religion, it's all of those various things. But again, it's just this continual undercutting of what have for so long been just basic principles, which is that, you can't deny somebody services because of, sex, age, orientation, disability, etc. And this just creates a situation where all a person has to do is say, well, it's my artistic endeavor. And, they're off the hook for that. And the court did not in its decision set forth any way to really measure that. And that's just, it's very, very concerning. And I hope that, I hope that it isn't construed going forward too broadly. Thanks.
Thank you so much for that summary. I think that was really a very helpful covering of what that decision could really mean. So unfortunately, we have one more loss to talk about in this particular lineup for Jones v. Hendricks, and I'm going to ask Camille McKenna to give us a description of what the decision looked like in that case. Thank you so much.
Thank you. So I see this case as the Supreme Court essentially prioritizing finality of convictions over innocence. I think it is helpful to just kind of understand a little bit of how we got here. Congress passed the Anti-Terrorism and Effective Death Penalty Act in 1996, which is commonly referred to as AEDPA. And that limited post-conviction relief actions in federal court for state and federal prisoners. Just kind of explain post-conviction a little bit. A post-conviction action is sort of action that involves court review of a case after a person has been convicted at trial and after they have pursued a direct appeal of that conviction to an appellate court. That's generally what post-conviction involves. So AEDPA essentially put a time limit on when post-conviction actions can be filed. It limited the claims the federal court would consider, and it limited how many times a prisoner could file a post-conviction action in the same case in federal court. The Supreme Court has also come down with several cases interpreting AEDPA, and those have further limited prisoners' rights. A significant one is a recent decision where the court limited what evidence a federal court can consider when reviewing these sorts of claims. And unfortunately, I think Jones v. Hendricks is right in line with this trend. Mr. Jones was convicted in federal court of possessing a firearm as a felon. He lost his direct appeal. He brought post-conviction relief action, and he actually won his first post-conviction case, although it was a win that didn't impact his sentence. So he essentially had to serve a really extensive sentence over 25 years. So as he's serving his sentence 19 years later, the Supreme Court of the United States issued an opinion that was favorable to Mr. Jones, interpreting the statute that he had been convicted of. The Supreme Court also made this decision retroactive, so it applied to him. The court essentially said that in order to be convicted of being a felon in possession of a firearm, the government had to prove beyond a reasonable doubt that the defendant knew at the time they possessed the firearm that they had been convicted of a crime punishable by more than 1 year in prison. And when Mr. Jones was tried, the government did not have to prove this required element. So he was essentially sitting in prison for potentially non-criminal conduct, and he was potentially innocent. Obviously, given these new developments, he tried to pursue a second post-conviction action in federal court. And he lost in the district court, he lost in the 8th Circuit, and he went up to the U.S. Supreme Court, and they said that he could not bring a second post-conviction action per AEDPA because this was not an exception enumerated in AEDPA that allowed people to go forward on kind of a second post-conviction action. And those exceptions are newly discovered evidence or a new rule of constitutional law. This was kind of a new interpretation of the statute that he had been convicted of. So he was essentially unable to seek any relief in federal court. They would not even let him in the door. Mr. Jones is actually still in prison. He appears to be at a halfway house, but will be released later this year. But here you have someone who went into prison when he was, according to my math, roughly about 23 or 24. He spent his 20s, 30s, and now most of his 40s in jail for potentially non-criminal conduct, and he was denied the opportunity to be heard on this claim. Unfortunately, I think this is really in line, as I said before, with how the court is going with these cases. What we can do, I think if you have the time, read Justice Jackson's dissent. It's very clear. It's very straightforward. And, you know, her take on this is that we need to urge Congress to respond. And I think in Rhode Island, that means speaking to our congressional delegation. There has been some kind of luck with legislation recently in terms of the Second Look Act, where we are trying to get, get courts to relook at sentences after the fact. And I also think on the state court level, it's really important that we prevent the state courts from following suit here. We want to fight any sort of court action or legislation aimed at mirroring the current state of the federal post-conviction law, because it is not going in the right direction. And I think it's really important to fight that both in court and up at the State House. This unfortunately is this law, the law around this case is super complicated, but I think Justice Jackson's dissent is really clear and worth a read. Thank you.
Amazing. Thank you so much. And thank you also for bringing up that dissent, because I agree with you. I think it was well worth a read in the decision. And also thank you for contextualizing that and like what we can do in Rhode Island to help prevent the same kind, that like further harm from this. So thank you again so much for that summary. We're actually going to turn now to a First Amendment decision that also came out this year, this time a victory for freedom of speech. And I'm going to ask Jared Goldstein to talk about these two cases for us, please.
Hello, everyone. Good evening. Hope you're doing well. First of all, these cases aren't exactly First Amendment cases. The court doesn't actually reach any First Amendment issues. They're really statutory construction cases, and I think it's fair to call it a civil liberties victory, but a pretty limited one. So here's the issue in the case. You know, should social media companies like Facebook and Twitter and YouTube ever be liable for the harms caused by content posted by users? And if these companies could be held liable, you know, what would it mean for free speech on the internet? So these questions are posed by, but not fully answered by these cases, the Twitter versus Tomna case and Gonzalez versus Google. Here's how the cases came up. They're each brought by victims of terrorist attacks, one on a nightclub in Istanbul and the other an attack in Paris. There's a federal statute, the Anti-Terrorism Act, that allows U.S. victims of terrorism to bring suit for damages against not just those who perpetrate acts of terrorism, but those who aid and abet acts of terrorism. So the plaintiffs in these cases sued Facebook, Twitter, and Google, which owns YouTube, for aiding and abetting terrorism. The social media companies, as I'm sure everyone knows, allows anyone to upload content, and through the magic of the algorithms that are programmed into their software, the sites promote this content to users who are likely to be interested in them. So if you click on cooking videos on YouTube, you'll start getting recommendations for more cooking videos, and you'll start getting ads for cookbooks. Or, as is more relevant to these cases, if you seem like you might be interested in ISIS or Al-Qaeda, YouTube will start giving you recommendations for videos promoting ISIS and Al-Qaeda. So the algorithms direct content to users that might interest them, and the companies profit by selling advertisements to accompany the content. So the plaintiffs allege that the promotion of videos and other content supporting ISIS and Al-Qaeda amounts to aiding and abetting terrorism, sufficient to make YouTube, Facebook, and Twitter liable under the Anti-Terrorism Act. So what they argued was YouTube and these platforms were critical to ISIS's growth, that it allowed them to reach and recruit new members and to promote its message. The plaintiff alleged that the platforms, well, first provided, these media companies provided platforms to ISIS and Al-Qaeda, that they provided substantial assistance to terrorism, that the companies knew that their platforms were being used to promote terrorism, that they profited from the use of their sites, and they failed to do anything about it. But in a unanimous opinion, however, the Supreme Court rejected this argument and held that what social media companies do in directing terrorist promoting content to users does not actually amount to aiding and abetting. Liability for aiding and abetting, the court says, requires a higher level of blameworthy activity. It requires the defendant to support the evil aims of the wrongdoer, as the court put it. And the court compared it to some other, more innocent behavior. For instance, the makers of poster board and magic markers can't be held liable for aiding and abetting if their products are used to make posters supporting crime, or a cell phone company isn't liable because criminals use cell phones to plan and promote crime. That is, they're not aiding and abetting simply by offering cell phones and services. And here the court says YouTube had no interest in promoting terrorism, and it treated ISIS and Al-Qaeda, the content supporting those groups, in the same way that it treated all other content. It was the algorithms, the court said, not YouTube that promoted this content. I'm a little troubled by the court's approach here, because I think what these companies do is somewhat more than what the makers of poster board and magic markers do, or what cell phone companies do. I mean, suppose that there were no algorithms, and what YouTube did instead was that it had human agents who curated all the videos they received into different categories and then promoted each category. So YouTube receives a bunch of cooking videos, and so they have someone who's hired as the cooking video agent who organizes all the cooking videos into a cooking video channel and helps promote those videos. And there's another agent who is in charge of organizing all the ISIS and Al-Qaeda promoting videos into a channel, and it finds ways to promote ISIS and Al-Qaeda on YouTube to users who want to hear about them. So if all this were done by human agents, it would look a lot more like YouTube is actively supporting ISIS. Should it really matter, that YouTube has figured out a way, a much more efficient way to organize and promote its content, so that it can do it through algorithms and without human agents? So, is it really different? On the other hand, ACLU's point of view in these cases, which I also find persuasive, is that it would chill a lot of speech on the internet if social media companies could be held liable for content posted by users. And there's a lot to be said for that. That is, if they could be held liable when content promotes crime or wrongdoing, they might prohibit a lot of content from being posted out of fear of liability, and there'd be a chilling effect. They might promote content about abortion, say, for fear that it might promote abortion in states now where it's illegal, or they might prohibit speech that might be defamatory, such as allegations of sexual harassment, like those posted in the Me Too movement. So I think it's fair to describe this as a civil liberties victory, but again, it's a limited one because the court is just interpreting the statute aiding and abetting, and the court didn't address a couple of other big issues that are floating around in these cases. I mean, first, the court didn't address the scope of Section 230 of the Communications Decency Act, which generally immunizes these social media companies from liability for any content posted by users and immunizes them for any good faith efforts to moderate content. So the court didn't address the scope of liability or the scope of immunity under Section 230, and the court didn't address the extent to which the First Amendment has any application here. That is, does the First Amendment limit what Congress or any other government can do to impose liability for platforms for content that they host? That is, are there any First Amendment limitations if the government chooses to require companies to monitor or limit certain kinds of harmful content, whether it's content that promotes terrorism or that promotes race or sex discrimination or that promotes medical disinformation during a medical emergency or that promotes election misinformation? Does the First Amendment have anything to say about government efforts to get these social media companies to police their own content? Or does the Constitution require the internet to be, the Wild West, or however we imagine the Wild West to have been, a libertarian paradise where harmful speech and wild claims can go unchecked? Or can the government do something about it? These questions weren't decided by the case, and we'll see, when those cases come up, in some future term. So thanks.
Thank you so much for that. And thank you also for clarifying the scope of those cases. That was actually very helpful for me as well. So thank you so much. I just want to quickly remind everyone, again, there's a Q&A box. Please, if you have any questions at all, please put those in there. We'll get to as many as we can at the end. But now we're going to turn to actually some ongoing litigation concerning reproductive rights. And I'm going to ask Lynette Lebinger to please talk about these two cases.
So I know this is a Supreme Court review, and there was action in this matter before the Supreme Court, but it is really a work in progress, a very disturbing work in progress. So I'm going to take a longer lead-in to get there. Medication abortions in the United States are usually accomplished these days by taking two drugs, mifepristone, which is also called RU-486 or Mifeprex, followed by misoprostol. Now, the mifepristone was first approved by the FDA in 1996. They expanded the approval in 2000, and at that time, it was approved for use for medication abortions at 10 weeks and required a doctor's visit. ACLU National, in some of its brief writing, has said that since these approvals were put into place, more than 5 million people in the United States have used mifepristone for medication abortion and miscarriage treatment and management. And the two-drug medication abortion regimen approved by the FDA now accounts for more than 50% of all abortions performed in the United States. In 2021, after the pandemic impacted access to healthcare and in-person visits, the FDA approved a mail order delivery of the medications. So now let's fast forward. We need to stop in 2022 to the Dobbs decision, because the Dobbs decision, in my view, changed everything, because what had been viewed as a fundamental right, whether it was called a woman's right to decide whether or not to carry or terminate a pregnancy, or right of privacy, or right to an abortion, however it was phrased, and the Dobbs decision went through and struck them all down and said, there is no right to an abortion, and there's no protection for women. And that basically gave the green light to the case that was filed at the end of 2022 by a group of doctors and a doctors association who don't perform abortions at all. But they filed their lawsuit, hand-selected a court district in Texas that only has one judge, so they knew who they were getting. And that judge had been active in the anti-abortion movement before he was appointed to the court. And they claimed, and that judge, not surprisingly, agreed, that even though they don't perform abortions, they had a recognizable injury, because they claimed they had to treat patients who came to them for adverse consequences after obtaining a medication abortion, and that having to provide those services constituted irreparable harm to them. And the judge, in ruling in their favor on granting a nationwide preliminary injunction disregarded over 20 years of statistics showing the safety of medication abortions. His biases were shown by the fact that he called the doctors who perform abortions abortionists, which is a pejorative term. He characterized those doctors as having only a profit motive and not being interested in the health or safety of their patients. And he referred to the fetus as an unborn child. In deciding that the doctors who came forward had an irreparable injury if this FDA approval were to stand, he disregarded the interests of women who are dependent upon medication abortions, particularly those who don't have access to abortion facilities or reproductive clinics in their states. And he didn't do any balancing for their interests and simply granted an injunction requiring the FDA to withdraw all of its approvals for mifepristone. Now, if the drug is not FDA approved, then drug companies can't sell it or market it. And doctors who prescribe it, they could still prescribe it, but they may be liable if there's a bad consequence. So the case then was taken up on appeal to the Fifth Circuit. And the Fifth Circuit has not rendered a decision in the appeal yet. When it came to the Fifth Circuit said, well, we are going to stay that part of the case involving the original FDA approval, but not that part that was decided in 2021, which expanded access. So the case went up to the US Supreme Court on a very limited basis to ask for a stay pending appeal. And on a 7-2 decision, the Supreme Court fortunately ruled that they would stay the injunction, which means that everything is still in place. FDA approval is still ongoing while the case is pending and until it gets to the US Supreme Court. Now, when that will happen and what happens at the end of that, we don't know. Among the significant factors of the lower court decision is it didn't balance women's interest in obtaining an abortion or other medical treatment. And that's because of the Dobbs decision, basically considering it not important. And the court's reasoning is really, this is the lower court, very expansive in allowing a private organization to upend medical and regulatory decisions that have been relied upon by the entire country for over 2 decades. So we don't have any final outcome. We're just sort of holding our breath on this one to see what happens next. Thank you.
Thank you so much, Lynette, and thank you for that. And I know that's definitely going to be one of the big issues that we're going to kind of have an eye on for probably many years to come. So the next decisions that we're going to turn to, I'm actually going to ask our executive director, Stephen Brown, to go over those. So I'll turn it over to him.
Thank you, Hannah. I actually have the privilege of briefly reviewing 3 key decisions this term, which were favorable to civil liberties, somewhat unexpectedly so to some extent, but they also each come with a very large asterisk. And once I'm done very briefly explaining the cases, I'll explain that asterisk. The first case, which you see on your screen, is Allen versus Milligan. This was a redistricting case out of Alabama, where the state legislature managed to gerrymander its congressional districts so that even though the state has a 27% Black population, they managed to make only 1 Black majority district in the state. This was classic racial gerrymandering. A number of individuals and organizations filed a lawsuit challenging it. A 3-judge panel, which included 2 Trump-appointed judges, agreed that it was not even a close case, that this was clearly illegal under the Federal Voting Rights Act, which prohibits discrimination in voting, and they ordered that a new map be drawn. The state appealed the decision, and the Supreme Court ultimately, I won't go into all the machinations that occurred beforehand right now, but ultimately by a 5-4 vote, The Supreme Court agreed that the gerrymandering was illegal under the Voting Rights Act. They rejected the challenge that the state brought, arguing that to look at race at all in gerrymandering was unconstitutional, and therefore there couldn't be a race-based remedy for splitting up the districts the way that Alabama had done. This was a very important decision. If the court had ruled the other way, it would have completely gutted the Voting Rights Act. 10 or so years ago, they partially gutted it. They got rid of a very important provision dealing with pre-clearance, which meant that especially in the southern states that had long histories of racial discrimination, they had to get pre-clearance from the Department of Justice before they could change their voting practices. The court struck that down. And as a result, all the southern states came up with all sorts of ways to make it harder for individuals to vote, and particularly racial minorities. So there was a lot of concern that they might put the final nail in the coffin of the Voting Rights Act with this case. But again, by the skin of our teeth, a 5-4 vote, they didn't. So the Voting Rights Act stays alive for another day. The second case was also an election case, which had even more far-reaching consequences, I think. It was also another redistricting case, although this one dealt with partisan political gerrymandering rather than racial gerrymandering in North Carolina. Now, it's important to note that a few years ago, the United States Supreme Court said the federal Constitution does not give the courts any ability or right to interfere with political gerrymandering, that is a political issue, and it's not one for the federal courts to get involved in. That was a terrible 5-4 decision to begin with. This one tried to take it one step further. In this instance, the North Carolina Supreme Court said that the partisan political gerrymandering that the state legislature had engaged in violated the state constitution. The state appealed the decision and argued that there was a provision in the federal constitution that essentially bars the courts from in any way intervening in what a state legislature does when it redistricts congressional districts. This is a really far-flung theory. It's called the independent state legislature theory. It's one that was first broached by former Chief Justice William Rehnquist in the Bush versus Gore case. We can't forget that one. This idea that the courts had absolutely no ability to interfere with state legislatures when they did redistricting. The idea that the Supreme Court was even considering accepting that theory was extremely concerning to anybody who follows election law. But fortunately, by a 7-2 vote, I'm sorry, a 6-3 vote, the court rejected this theory of an independent state legislature and said state courts do in fact have the ability to make sure that legislatures are complying with all provisions of the Constitution when they do gerrymandering. So it still allows state courts to have some role to play when redistricting takes place and there are questions about its legality. A decision the other way would have been absolutely disastrous for election law across the country. Then the final decision I want to briefly talk about is Holland versus Brackeen. And this had to do with a challenge to the Indian Child Welfare Act, otherwise known as ICWA. ICWA was passed by Congress in 1978 to establish some very basic requirements to protect Native American children from removal from their homes and communities. Now, you probably know that this country has a very terrible history with our Native American population in terms of removing children from families, placing them in boarding schools, denying them any attempt to learn their culture, to speak their language. And this took place for decades. And it's really one of the many stains on our history in terms of equal rights for all. And in response to that, Congress passed this law designed to provide some protection to Native American families. One of the amazing statistics that I saw in one of the briefs that was filed in the case was that before ICWA was adopted, approximately 1/3 of Native American children were taken from their homes by state welfare agencies and private adoption agencies. And even more shocking, 85% of those children were placed outside of the extended family or community care with their tribes. They were given to non-native people. So ICWA sought to change those consequences by establishing all these procedural protections when native children face removal from their family, and it creates a preference for the extended family to be able to adopt the child or for tribes to be able to adopt the children. This lawsuit challenged that whole process and argued that it was unconstitutional for a variety of reasons. And there was great concern that this court might agree with that and completely undermine this very important law designed to protect Native American families from this, almost 2 centuries of discrimination. Fortunately, again, the Supreme Court did not go that route. They rejected the challenges that were brought, and at least for now, ICWA remains a viable method of protecting Native American families from a totally inappropriate removal of children outside of the tribal network. So, those are 3 cases where everybody was on edge, worrying that the Supreme Court might rule the other way in 1 or possibly all 3 of them. They did not. But there are 2 points I want to make about this. First, when we're thanking them for these decisions, we're really thanking them for not being even more awful than they were this term with some of the other cases you've already heard about. None of these cases expanded civil liberties. They just preserved the status quo. They didn't change, they didn't undermine decades of precedent like some of the other cases, the affirmative action case, the wedding designer case, which really took us backwards. These cases simply kept us at the same place, which is good, but I don't think it deserves a pat on the back. I think it's also important to keep in mind that the Supreme Court itself was responsible for everybody being concerned because they're the ones that agreed to consider these really wild issues. They didn't have to take a case and decide whether this independent state legislature theory made any sense. The courts below had never accepted it. The Supreme Court could have let those decisions stand and not have gotten involved. The very fact that they decided to get involved is what was of such concern. And again, it's why we shouldn't be necessarily giving pats on the back for thanking the Supreme Court for saving us from something that they threatened to do to us. So at the same time, though, we have to take what we can get with a court that is very antithetical, I think, to a lot of basic civil liberties and civil rights. So in each of these instances, as I said, we get to keep them and hopefully they will stay alive through future court challenges. So after going through those 3 cases, one of the big questions then is, if things are so bad, what can we do? And I think there are a few answers to that, and Camille actually was very helpful in addressing a few of them. I mean, first, I can't emphasize enough the importance of people speaking out and raising concerns about what the Supreme Court is doing. I have little doubt that it's because of the scrutiny that the court has had over these past year and a half since the decision overturning Roe versus Wade was decided. I think that I won't call them the mushy middle of the court because they're not in the middle, but the mushy right of the court is trying to take it a little slower before overturning decades of precedent every time they can. And I think to the extent that we keep on raising concerns about these decisions that they're issuing that do in fact take us backwards, I think that does have a public impact on some of the justices and how far they're willing to go in accepting some of these right-wing agenda cases that are being appealed to the court. A second thing, again, is something that Camille mentioned, is the ACLU and others who are working on civil rights and civil liberties have to look much more closely now at working in our state courts to protect our rights. We cannot count on the United States Supreme Court and therefore the federal courts below them to do the right thing. But we can look to our state courts to try to provide protections. We have a state constitution, and we need our courts to interpret it in a way that does not go in lockstep with the way the United States Supreme Court is interpreting the federal constitution. And then finally, something that everybody can help with is working at the state legislative level. The best example of that is something that I think everybody on this webinar is familiar with, and that was the Rhode Island General Assembly's actions a few years ago to codify the principles of Roe versus Wade into state law, so that when Roe was finally overturned by the Supreme Court last year, we had in place strong protections under state law. And I think that's something we're going to have to do more and more of. I think people who are interested in the legislative process should get involved in looking at what are some of the statutes we can pass to provide protection just in case the federal courts don't provide the protection that we've had for so long. So I hope these are things that those of you watching will think about as time goes forward, and as this court, unfortunately, I think keeps on leaning more and more to the right. So with that, I'll turn it over back to Hannah.
Amazing. Thank you so much, Steve. That was also very, very helpful summaries of all those cases. So really quickly, just because, there really is no rest for the weary, we do already know a handful of the cases that the Supreme Court will be hearing next year that could have a significant impact on civil liberties. So we thought it might be kind of interesting, maybe helpful to talk about those very briefly. I will be very, very brief about these cases. Certainly there will be more than enough time in the upcoming months and the upcoming year to think about their implications. Probably another event that we do to talk about them. But I do just want to very quickly talk about 3 cases that the ACLU of Rhode Island knows that we will be watching really closely. The Supreme Court has so far agreed to hear only a very small number of cases for the new term. They will likely announce a large number of new cases for review when they return in October. But the first that we already know about worth noting is Atchison Hotels LLC v. Haufer, which is a case that involves a hotel that was sued for failing to publish information about their hotel accessibility on their website, which is required by the Americans with Disabilities Act. The important issue here is that the court will decide whether an individual who has no plans to visit that hotel nonetheless has standing as a so-called tester to challenge the hotel's violation of the law. Testers have often been used to determine compliance by businesses with anti-discrimination laws, so the court's ruling in this case could have very major ramifications beyond the ADA. The second and third cases cover a similar issue, and it's actually one that the ACLU of Rhode Island has litigated over in the past few years, and they relate to public officials blocking constituents or other individuals on social media platforms. Linkey v. Freed and O'Connor Ratcliffe v. Garnier will determine when and to what extent a public official's social media activity relating to official business constitutes government action that's actually subject to the First Amendment. The ACLU of Rhode Island believes that public officials may not block individuals from their social media accounts, which are being used to communicate information that's related to their public work. And in fact, here in Rhode Island, we have successfully sued officials for doing just that. So these court cases will determine whether we'll still be able to hold government officials accountable for blocking constituents from their social media activities. And so I just want to remind everyone again, there is a Q&A box. We're going to turn to questions in just a second, but I'm just going to kick it back over to Steve for one more small thing before we head to our Q&A portion of the event. And again, I just want to thank everyone for being here. I want to thank all of our amazing panelists. Again, these were incredibly helpful summaries, really helpful and clarifying for me as well. So I'm just so grateful that they were all here today. I'm really happy that everyone joined, and back to you, Steve.
Thank you. I also want to thank all the panelists for their participation. I want to thank all the people watching for attending and wanting to learn more about the Supreme Court's term and some of the important civil liberties issues they discussed. But as you'll see on the screen, I think you have an idea of what my pitch is that Hannah asked me to speak. We ask you to donate to us. The work that we do, whether it's the litigation we're involved in, putting on special events like this one, we're only able to do thanks to our supporters. You can do it 2 ways. You can go to our website, just go to riaclu.org/donate, or for you more tech savvy people, there's a QR code right on the screen, and you can get to that site from there. if you'd like to. I just want to emphasize that you as our supporters are how we are able to do everything we do. We have 30 cases in the courts at any given time. We're lobbying on hundreds of bills every legislative session, but we can only do that if we have the support that our members and donors provide. So please, if you like this, we don't have a tote bag for you, but if you liked listening to this and you felt it useful, I hope you'll give a contribution. And I'll turn it back.
Thank you so much, Steve. And then I'm actually going to make one more unofficial pitch, which is that 2 weeks from now, we're wrapping up the Supreme Court term right now, but 2 weeks from now, we will also be wrapping up the 2023 legislative session, specifically for Rhode Island. So there's a lot of different political activities have concluded for the year. On July 26th, which is a Wednesday, at the Cranston Public Library, we are going to be holding our 2023 legislative wrap-up. So we really hope that we'll see you there as well. And so now we're going to turn to questions. I'm going to start with the first question that I see, and I believe that this was relating to the affirmative action cases, and it mentions the ACLU. So I'm going to ask Steve to take this one, since it specifically asks whether the ACLU intends to challenge this decision in some kinds of cases.
Well, it's hard to say. The court has ruled that the use of affirmative action, the specific use of race, is unconstitutional. So I think what we're going to have to do is watch and see how it gets interpreted. Diane gave really good examples of the sort of mess that the court has left in trying to figure out exactly what they mean. I'm sure that if there are challenges brought in Rhode Island, we will be involved in some way with affected parties in trying to tease out the court's decision and make sure that it is not interpreted in an overly broad way that really harms the ability of colleges and universities to have a diverse student body.
Great, thank you so much, Steve. I actually have another question about that case for Diana this time, if that's okay, which is what, if any, the impact of the affirmative action case could have on employment practices.
Well, that's a complicated question. So, the employment is covered by Title VII of the Civil Rights Act, and it has been assumed, though not directly announced by the Supreme Court, that just as with educational diversity, race can be a factor in certain kinds of employment decisions. It can't be the sole determinant, but it can be put into place as part of the calculus, particularly when you're dealing with an industry where there has been historic underrepresentation. So the question is then raised, well, what does this decision do to that? Are those kinds of limited uses of race that have been applied in contract set-asides, in some kinds of hiring where there have been historically underrepresented people based on race or gender, is that still going to be allowed, or is that affected now by this decision? And I think that that's not clear, because the court talked solely in terms of the Equal Protection Clause and Title VI, which is the anti-discrimination statute applying to organizations such as universities that get federal funds, and didn't talk about what does this mean for the anti-race discrimination provisions of Title VII. So I think that's an open question, but I'm sure there is a lot of concern among employers who have thought that they were free to use race as a factor in an overall decision.
Thank you so much for that answer. That was also really helpful for me. I actually also have another question for Sonia about 303 Creative, which is there any logical basis in the court's decision to prohibit someone from making the same argument about, for example, making a cake for an interracial wedding?
Well, I'd like to say there's not. But I think the problem is that when you're talking about a person's firmly held beliefs, when you're talking about religion, when you're talking about all of these things, all of it can sort of get tied together and warped around. So I'm not going to say that it can't. I'd like to say it couldn't, but I'm not going to do that. I think there's probably somebody that has some belief out there, and they would say, hey, look, my religion is that, only a particular group can have cakes made, and that does not include African Americans. And I think it might fly. It's just very concerning.
Thank you so much. Okay, let's see. I have another one this time for Camille about Jones. We're having a hard time understanding how a court can acknowledge that a person is innocent of a crime but still keep them locked up. Is there any way to challenge that situation?
I mean, I think in state court, thankfully, we still have avenues to do that. I think in federal court, this decision has really shut the door on that. If, given his circumstances that it was a second post-conviction action, I do think though there might be, other avenues to pursue with, say, like a clemency type situation, which I know the federal government has done that with some other sorts of offenses where they've commuted sentences. So Mr. Jones, I did a little bit of research on his case because I like the backstory to it, and he is going to get out. He's probably at a halfway house right now. He is going to be off this sentence in September. So I don't know if that played into maybe why they didn't pursue anything other than this sort of litigation. But I think stateside, you definitely could try to pursue post-conviction, and with the federal government, like a commuting of the sentence, clemency, that type of thing. But I was also very troubled with the sentence he received. He received it was about a 29-year sentence for basically being a felon in possession of a firearm. And it was based on the fact that he had 9 convictions since becoming an adult, which he probably accumulated over about a 6-year period. But that was the maximum he could receive under the sentencing guidelines, which, this is like he's sentenced in 2000. So that was, I think the courts were maybe more apt to be bound by the guidelines back then, but it's still like a really, really excessive sentence for this offense. And if someone, his age, very troubling. It's like shocking, actually.
Thank you so much for that answer. So I'm gonna just read this question and then toss it out to anyone who feels inspired to answer it. Can we address the issue of standing as SCOTUS has considered it in 303 Creative or the FDA case? And also if someone could define the term tester, a civil liberties tester, or if there's anyone who feels equipped or compelled to answer that.
I can say one thing, about standing in 303 Creative. The court took the case based on a stipulated set of facts that turned out not to have any basis in reality. So it's probable that, but for the stipulation, the plaintiff in the case might not have standing because they weren't actually going to make a website. And there was no, for the, for a same-sex couple, there was no same-sex couple. So the whole case is kind of fictitious to begin with, but, the court, takes the cases as they get them. And so there's a stipulated set of facts that, suggest that there was a real controversy there. Albeit in this case, it was fictitious. I mean, there's a bunch of cases this year where the court, did some weird things with standing, that, they unanimously held in the private suit about the debt, the Biden administration's debt program, that there was no standing, but that Missouri had standing, that they found standing based on this, this worry that the website designer might have to make a website for a couple that they disagreed with was enough to find standing. I mean, the whole, the court, I mean, the rules of standing are pretty straightforward and are easy to describe, but the way the court applies it now makes it clear that, they're standing when the court wants to take a case and no standing when the court doesn't want to take the case. The term is, has made quite a mess of standing.
Yeah, it was certainly interesting to follow as these decisions came out to see how that was addressed. Is there anyone who wants to expand upon the term tester?
I can do that.
Thank you.
Testers are individuals that are employed most of the time by law firms or organizations to go around and try to find things that violate the ADA. Number of years back, I was involved in defending some litigation where testers were going to certain places of public accommodation and making complaints about handicap access, even though they were individuals that hadn't used the facility or weren't honestly going to use the facility. Those individuals do that because they tend to get paid an amount from the resolution for doing those sorts of things. And there's this whole sort of industry of people that do that type of thing.
Great. Thank you so much. I actually have another question for Jared very quickly. Do the Twitter and Google decisions have any relevance to the question as to whether the First Amendment applies to public officials' social media accounts? Is there any connection between those two, or any thoughts on how the Supreme Court might rule on those cases that are going to be coming up in the next term?
I would say, at least not on their face, that I would say the cases don't have anything, to suggest how the court will come out, because I mean, the case, this term's cases are really statutory construction cases, although the court does read the statute in a way to protect, read the statute narrowly in a way to protect the social media companies from liability. So to the extent that there's like an underlying free speech concern, that I think that, it might suggest that they will, I don't know. It's, I say that, I would just say it's, I wouldn't read much into these cases for what that case is going to decide, because it's a very different issue about the liability of a public official, who's taking action, because of speech, whereas here, what the companies had done wasn't to promote their own speech, but to provide a platform for other people's speeches. So the issues are, I think, quite different. There probably are other cases that would be more on point, that would be helpful to predict how the court will come out in the public official Twitter type case.
Amazing. Thank you so much. So I know there are still some questions lingering, but I think in the interest of making sure that we're able to end the webinar on time and able to get everyone back to their evenings, I think that we're going to start wrapping it up. If you still have an outstanding or lingering question, please email us. Please email us at info@riaclu.org. You can find us on a number of social media platforms. We would be more than happy to answer your question. I'm so sorry we didn't get to all of them tonight, but I just really want to make sure that we're making sure that people can get back to their evenings on time and not taking more time away from your Thursdays. But I just want to say again, a huge, huge, huge thank you to our panelists. A huge thank you to everyone who was here to listen. Again, just just a friendly reminder that our legislative wrap-up will be coming up in 2 weeks. We really hope to see you there. We're really happy to be able to start doing more events again as we're kind of emerging from the thick of COVID. So we're just really excited when people show up and we're able to talk to all of you. Finally, the last thing I just want to mention is that you will be receiving a survey following this event. There are a couple questions on there. One of the ones we're really interested about is how you feel about virtual events, especially since, like I said, there are a lot of organizations that are returning to in-person events more so. So we'd be really interested to hear your thoughts on that. Any other feedback you have is always incredibly valuable. We really do take it seriously because we want to make these events as useful for you as possible. So again, thank you so much. Thank you again to our panelists. Thank you to everyone who showed up. I hope you have a great Thursday, and hopefully we will see you in a few weeks at our legislative wrap-up. Have a great night, everyone.